It's often considered an honor to be appointed executor. And then once you're actually in that role, you're like, oh, this is a lot of work.
Yeah. Welcome to Money Talks Life Lessons. My name is Melissa McGuire, co-host of today's podcast and co-founder of Isle Wealth with Raymond James. I'm here today, of course, with my fabulous co-host and co-founder, Joanne Caban.
Hey, how's it going?
Today, we will be joined by Samantha Russell. She is a lawyer with Solus Trust. Solus Trust is an independent trust services company that we will chat with about giving a gift of peace of mind. So we're going to talk about professional trust services and how they work to protect families. And Samantha can fill us in on all of the intricacies and some of the fabulous reasons why we like to partner with Solus Trust. Hi, Samantha. Thanks so much for joining us today. I'm really excited about this topic and learning about how a professional trust service can really provide some guidance and help for estate distribution and such. So thanks so much.
No, thank you. Yeah, thank you for having me.
Before we really dive into the services and what all those look like, I wonder if you could share a bit about your background and how you found your way into trust and estate work.
Yeah, definitely. So I studied law at the University of Victoria, and then I started sort of articling, and I practiced at a shop that provided sort of corporate real estate and wills and estate services. And I just realized quite quickly that I gravitated towards the wills and estates area. So I have practiced sort of estate planning and estate administration at a local boutique here in town called Legacy Tax and Trust Lawyers for the last sort of 5 years. And I really, really enjoyed working with families to help them sort of navigate these more difficult conversations and solve these problems. And I just made my way to sort of Solus Trust about 6 months ago, and I'm really enjoying this new role. It's a little bit more hands-on working with families and just to give them sort of some peace of mind. These are difficult conversations to have, and I just really enjoy being like a helpful part of that role. We've all sort of worked with people in different industries that haven't been as helpful in a difficult situation, so I want to be sort of a positive part of a difficult sort of conversation and experience.
That's awesome.
Yeah, I think that's such a great point because dealing with money and estates, a lot of the times I find that people think naming a family member as an executor is almost like an honor, but it actually can be quite the task and a challenge for a lot of people. And when the time actually comes, it can be quite overwhelming. So to be able to have another option to use a professional like yourself that can take that heavy burden off when they're maybe going through a lot of grief and they're already feeling overwhelmed in an emotional state, for you to be able to step in and use your professional expertise to help the situation is huge. So I think this is going to be a lot of fun talking about this topic with you today. So for our listeners who might not be familiar with what a trust service actually does, could you maybe elaborate on that for us?
Yeah, so trust companies can offer many services. So you can appoint a trust company to act as your executor. So that's the person who administers your estate assets after you pass away. A trust company can be appointed as a trustee. So that can be of a trust that was settled sort of while you were still alive, or a trust that comes into effect after you pass away, like a disability trust, for example. And then you can also appoint us to act as your power of attorney. So that's appointing somebody to make financial and legal decisions for you on your behalf, sort of when you've lost the ability to do so yourself. And then we can also act as committee of the estate. So committee of the estate, it's a situation where someone hasn't appointed a power of attorney, but they've lost the ability to manage their finances themselves. So this is a court-appointed person who would then help this person, assist them in making sort of their legal and financial decisions for them. So there's a variety of services that trust companies provide.
That's great. And I wanted to do a follow-up question on appointing and a power of attorney when you don't have capacity, because we've come across that a few times with some of our clients, and I'm curious how that process actually works with the courts.
Yeah, so this is if you haven't appointed a power of attorney and you're needing to appoint a committee of the estate. So this is a court application. Essentially, you have to get two physicians licensed to practice sort of in BC, if we're talking about our province. And they have to confirm that that person no longer has the ability to manage their financial affairs. They then have to swear affidavits. So this can be quite a lengthy process, just because getting doctors to do this, to have the time to do this, can be quite, a push and pull. They're very, very overworked, and it's a busy field, of course. So then once you have those affidavits from those doctors, you can make that court application, and then a judge or a master essentially determines whether or not that person no longer has the ability to manage their finances. And then you're appointed committee, and so you'll have the authority to make all of those sort of legal and financial decisions. The caveat here is that court application can cost anywhere from like $10,000 to $12,000 currently. So
Wow.
that's a lot of money. So you're saving a lot of money by appointing somebody to act as your attorney, right? It's time, it's a huge, huge cost. So that's why oftentimes appointing an attorney is not the focus. It's getting your will in place. And of course, both documents are important, but it can be a huge, huge cost saving and time measure to have an attorney appointed.
Exactly. And we often hear a lot of our clients talk about not wanting to actually pay the fees to get one of these documents drawn up. But I think to your point here, the alternative option, if we haven't put one in place, is the cost could be that much more. And it can be lengthy when, a loved one actually needs that support and we don't have it in place because we have to go through that formal process.
Yeah, definitely. It is one of those things where, to be honest, a high number of people are either going to, have some cognitive issues near the end of their life, or perhaps not have the energy to manage their own finances anymore, right?
True.
There's two types of attorney appointments. So there's one called an enduring power of attorney, which means that if you get to the point where you're just feeling overwhelmed and you don't have the ability anymore to manage your finances, you're still cognitively okay, but you'd like someone else to take over in that role, you can just direct them in writing to start acting. So then that person can assist you right away. Then there's another document called a springing power of attorney. So it doesn't come into effect until you've actually lost capacity, but it's helpful to keep in mind that you have both of those options. Like, I think it provides some peace of mind to have that enduring power of attorney in place typically, because then you have the option, right? You can have somebody managing that aspect of your life for you if you just get to a stage where, you've had enough. It's not what you want to spend your time doing. You want to enjoy those years at the end of the day.
So, Samantha, I just wanted to ask a question about the springing power of attorney that you just mentioned. And my question surrounds sort of when that can take effect. So my understanding is when you do a springing power of attorney, there has to be like you bring that into effect when you anticipate you'll no longer have capacity, right? And then somebody has to deem you as not having capacity. How easy do you find it for the springing power of attorneys to work when oftentimes people don't realize they don't have capacity anymore?
This is so the attorney's been appointed in this hypothetical scenario. It's just giving them sort of the authority to act. So this is like a really challenging middle ground, to be honest with you. So usually it relies on sort of a relative or the person who's been designated as the healthcare representative who has sort of closer insight into this person's life and can manage and arrange to have them visit a physician and get themselves evaluated. But this can often be a really tricky time for families, right? Because as we know, cognitive decline, it comes and goes, right? You can be diagnosed with dementia and you're
Yes.
still having lucid moments. So it's a really, really challenging stage for families. And I actually have a number of clients right now who are in that stage of the process. And what's really, really helpful is having that healthcare representative appointed. So in BC, this is somebody that you've appointed to make healthcare decisions for you when you're no longer able to do so yourself. So having that touch point person is really, really helpful just to make sure that they're the ones that can arrange for these appointments, because it is a really difficult stage. Because cognitive decline, it's not a black and white situation. It is sort of typically like slower in its progression. So it can be a really, really challenging stage and really, really tough stage for families to work through.
And I think that, just to clarify for some of our listeners who might not know the name of the document fully, is it can be called the representation agreement. Living will is another common term that we hear across Canada, or medical directive.
Yeah,
So-
it definitely depends on the jurisdiction.
So again, because you touched on a really important thing by talking about the representation agreement or healthcare directive, that doesn't involve finances. And I've noticed in here when you talk about the trust services, you've got the trust services, the power of attorney, the executor services. Everything in here has something to do with sort of the financial aspect. So what happens if somebody doesn't appoint a healthcare person? And then, Solus then has to sort of start trying to act as a power of attorney, but doesn't have the capacity to help with anything when it comes to health because it's not sort of part of the financial document sector.
So typically, if somebody doesn't have a healthcare representative appointed, and let's say there's an example where somebody needs to be moved into a care home, but they're not able to make that decision themselves. So as power of attorney, we would be paying for that care home. We'd be making all of those decisions. But if we don't have somebody who can make the call in terms of what care home they're moved into, typically what happens is there's sort of a next of kin list. So we'll go to the next of kin, and if there's no next of kin, then the PGT has to be appointed, which is challenging. So this is sort of why I recommend to clients. So it's tough, right? Because it's a role that has a lot of responsibility. So you want it to be somebody that you trust, but I guess it's important to know that if there is nobody, they will go to your next of kin. So if that's not who you're wanting in that role, and there's somebody that you prefer to have in that role, it's just important from your perspective to maybe have that control and just pick the best person that you think is there for that, suited for that role.
Why do you think that like continuity is so important and an important benefit when choosing like a corporate executor or trust services for or as a
Yeah,
trustee?
so oftentimes we see when people appoint an executor, sometimes the person that you trust the most, particularly when it comes to sort of managing your finances, is somebody who's either close to age as yourself or even a bit older than you. So, in terms of appointing a corporate trustee, for example, like Solus Trust, lawyers who work for Solus Trust may retire, but that entity is still going to be there and still be able to serve you. Whereas,
Mm-hmm.
if your executor that you've appointed passes away, you might sort of be scrambling to find somebody that, you think is able to fill that role. So that is sort of an advantage of having a corporate trustee in that role.
That seems like a super advantage.
Huge. And I mean, in our worlds, we often see a lot of our clients wanting to name their children as that first point of contact when it comes to being their power of attorneys, the executors. Sometimes they'll even name both children, one or the other, because they feel that that might be the simplest. Why would you say that that's in most situations actually not the case, that it's a little bit more complex than what they might initially think?
Yeah. So essentially, how I explain it to clients is you're essentially giving somebody a part-time job that they don't know how to do for a number of years.
That's perfect.
So
Um,
true.
which is very challenging, right? So it's going to be their first time approaching this, and they're not just approaching this in the best of circumstances either, right? They're grieving. So if we're talking about Joanne's example, where it's children that we're dealing with, it's a whole new stage of life when you lose your parents. Like it's a really, really tough transition, and that kind of grief manifests in a lot of different ways. But if you have service providers sort of reaching out to you constantly, referring to your parent as, the deceased person, for example, which is actually quite common, like that's pretty tough to deal with on a daily basis. So, corporate trustees, we have the advantage where we do this all the time. We're a little bit, less emotionally, of course, involved in the situation. And it just, it makes things, I think, simpler and easier for the family. It definitely reduces the potential for any conflict between the siblings as well, right? When emotions are high, the possibility for conflict is definitely there. Even just like simple examples, like oftentimes you're dealing with different financial institutions when you're administering an estate, and you're going to be on hold for hours and hours and hours, and that's just like a huge amount of time, labor that they're putting in. And oftentimes when parents pass away, you know children are in sort of their middle stage of life, they're building their career, they're raising their kids. It's just a lot of time, effort on their end. And with a corporate trustee, we'll do those things during business hours, and that'll all be handled for them at the end of the day. And I think the reason people gravitate towards appointing their children is that sometimes a corporate trustee can feel like it's quite an impersonal experience. But at the end of the day, a big part of our trust officers' roles are to develop relationships with the beneficiaries of the estates that we administer. So the beneficiaries would still be very involved in the process, and it's our role to look after them. We have a fiduciary obligation towards them to act in their best interests. So I think that's sort of where the distinction comes. I think there's maybe a fear that a corporate trustee is too far removed, but at the end of the day, I really think if you find the right fit for you, trust company wise, that you'll feel the exact opposite. That really really the trust company is just taking on the legwork that you would prefer that your kids don't have to do anyway, while still maintaining that strong relationship with them.
Yeah, that's such a
Mm-hmm.
valuable point that you've expressed, because we've had a few times where we've had clients who appoint a trust company, and then they're able to work in verbiage that they're going to be able to consult with their children, right? So the
Mm-hmm.
children
Mm-hmm.
are very much involved in the process. You know, maybe there's family heirlooms and jewelry that wants to be passed down specifically, and the trust company will work with those individuals to say, you know, do you want mom's ring? Do you want this, right? And it's not as if they just come in and they cut the children out altogether. That's not the case at all,
Right.
unless that's what the children request. So yeah, I think that's a really big misconception that a lot of people have, and there's, you know, a solution to that.
Hmm.
So you mentioned some of the difficulties of being an executor. Can you expand a little bit and sort of talk about maybe some of the common pressures that you might see executors face that they just sort of underestimate? Like in my mind, I go toward like family pressures, like, and maybe
Hmm.
some of it's not only just family discord, but like family wanting to know what's going on a regular basis. Like what types of those types of interfamily pressures do you see that you can?
Yeah, definitely. So I would say one of the biggest things is actually timing of distributions. So I would say in some ways, like Hollywood is our worst enemy on this one, because you sort of see scenes where somebody passes away, there's a will reading, and then you get a check in the mail like the next week, which is really not how this all works
Mm,
out. So I think what happens is if, let's say, one sibling is appointed as the executor, the other siblings are wanting to be kept in the loop.
mm-hmm,
And they're like, well, why haven't I received a distribution yet? And even in a best case scenario, a very smooth estate administration can take about a year and a half, 2 years. And really, that executor that's been appointed is just doing their due diligence to make sure they don't make distributions before, all the taxes have been paid. Simple sort of things like that. But because of, wait periods from CRA, that kind of thing, it can take a lot of time. But beneficiaries are anxious, and a lot of times people just want to wrap this up as well, which is more of the emotional piece of it, right? So there's lots of pressure from the other beneficiaries, and that can be quite stressful. There's also a positive obligation on you as executor to be keeping complete and accurate records of everything that you're doing in the estate administration. That alone can take up a lot of time, but those same beneficiaries are going to want to see exactly how you manage those funds in the course of those 2 years. And again, this is all familial relationships, right? So it's more complicated than just business relationships. So I find it's quite stressful. Just sort of intertwining this kind of family dynamic with managing finances. Just the interplay between the emotions and sort of the just administrative duties involved can be really taxing for the person
mm-hmm.
appointed executor.
Have you seen a situation where a family maybe started going down the road and the children started, or a friend or whoever they appointed started the executor, being executor, and realized this is way too much, I'm done, and, came to you and said, look, I need the professional help, and what was kind of going on at that time?
Hmm. Yeah, that's definitely a possibility. It's for sure, it can be a little bit complicated. So we can also act as agent for executor. So what that means is, let's say in your example, Joanne, this person is feeling overwhelmed. So we could essentially be appointed as their agent and take on doing all the legwork for them and sort of provide our knowledge and education. They're still ultimately in the driver's seat making the decisions, but we're sort of doing all the legwork for them. If they'd already started acting in their role and they wanted us to act on their behalf, it's possible. It's more complicated. It requires like a court application and sort of an extra cost to the estate. So
Mm,
in your example, I would imagine that we would canvass acting as agent for this executor instead. But I think that's one of our great services actually, because I think, as you said earlier, it's often considered an honor to be appointed executor. And then once you're actually in that role, you're like, oh, this is a lot of work. So I
yeah.
think it's one of like the great services that we offer, because then you can still not feel like you're not acting in that role like the deceased person wanted you to, but you have help with administering the estate. So I think it's a fantastic service that we offer.
Huge,
Mm-hmm,
huge. And what
mm-hmm,
a relief, right? So then they can focus their efforts on their family, and grieving, and be able to remove all of that administrative tasks off their desk, for
Hmm.
sure.
So, okay, so maybe this is more of a psychological question, really, in terms of, behavior management. But, how We've talked a lot about how using executor services can sort of take the burden of responsibility and time and everything for the role of being an executor off of a family. But how does this help by sort of making everything a little bit more impartial and reducing like conflict that, kind of naturally arises when money involves with grief at the same time? Conflict is a very easy place to get to. How do you find it helpful in your role? Because I know from personal experience that a family member is going to maybe be more difficult and maybe be not as kind to a family member as they would be with a professional trust service person. So how do you see your role as sort of conflict management or conflict reduction?
Yeah, so I think our role is very, very helpful if there's potential for conflict within the family. And honestly, let's be honest, most of us come from some kind of dysfunctional family. There's always potential for
Yeah.
conflict. So it's very helpful from the point of view that one, we have sort of the expertise and knowledge to impart to those beneficiaries in terms of setting realistic expectations for how this process is going to go. And there's just a little bit more faith that we sort of know what we're doing as opposed to having someone appointed who's either, who's probably never done it. But I think it's helpful because typically sort of old emotional wounds can come up in those dynamics too, right? So it's not even necessarily about whether or not this person's doing a good job being executor. It's just feeling frustrated and those sort of like, wounds coming to roost a little bit. And so it's really, really helpful. We almost sort of act it's a very sort of neutral role. And we essentially will have regular meetings with the beneficiaries and sort of provide that calm space. And it also, our role, I think, what is helpful, because I've worked with a lot of families where people feel like the executor isn't doing a quick enough job, for example, or not enough is happening regularly enough. So with a corporate trustee, you're going to have lots of communication the entire way along. There'll be regular meetings, so they're going to feel like progress is being made. Whereas with an executor who's not having these regular meetings, perhaps not providing as much communication, that's sort of where conflict is ripe to sort of escalate. So I think from that perspective, a corporate trustee it's a huge advantage from that perspective.
I think this segues really well into talking about trusts and managing family trusts. We had a client situation years ago where there was an addiction for one of the children involved, and there were siblings, and they were setting up a family trust. But at one point, they were going to name the other sibling as the trustee for this. And it caused a lot of anxiety for that other sibling because they were going to have to, in most honesty, have to decline the withdrawal of funds for the sibling that might want to take money out for drug use. So it was one of those things where originally the parents wanted to name, their other child as that trustee, but upon us having a bigger conversation, and had a conversation with the one son that was being appointed, he said, like, look, this is going to cause my whole family so much stress. So that's when we kind of introduced them to the whole concept of a trust service. And knowing that that could be removed from his plate and he wasn't going to have to be the one to tell his sibling, no, you can't have access to this funds. I'm sorry, that's the trust company makes that decision. It removed so much stress from the family. So I see that there's a lot of benefits for, maybe more complex family situations, but also kind of the idea around, we hear trusts being more for kind of like the rich and famous, like you were alluding to the TV families and things like that. That's often what I find a lot of clients think. But what is the reality around trust? Is it for people who have a large amount of money, or could it be for more of the average average person as well?
I work with a lot of clients, as you say, that would be sort of considered more the average person, to be honest with you. There's so many different trust structures available out there. So we do a lot of work with what are called like disability or Henson trusts. So these are not necessarily huge amounts of money, but they're just making sure that this person who's likely receiving sort of disability assistance from the government, there's certain asset thresholds that they can't surpass. Otherwise, they lose access to that disability assistance. So we hold these funds in a trust and sort of siphon out certain amounts to them on a regular basis to make sure that they have everything that they need, right? So these are not necessarily circumstances where you're dealing with sort of the ultra sort of wealthy rich and famous sort of archetypes. I mean, we've also got sort of alter ego and joint partner trusts, right? So those are trust vehicles, they're retirement vehicles for people who are 65 plus. They can transfer their assets into these trust structures, and they have a number of advantages, right? Sort of like wills variation protection, probate fee avoidance, privacy if you're worried about that in terms of the grant of probate application. So, and these are working with families again that are more sort of like your average family. You know, they own their home, they've got some savings by that stage in their life. So there's just it's a huge landscape out there. So trusts are certainly not just for the rich and the famous.
I like the concept that I can control from the grave. I know Melissa and I have talked about this for a lot. So I like the power of it, but I don't know what my son's going to say about that down the road.
That's funny.
You're not the only one, Joanne. So
I guess that this leads really nicely into our next question. Let's take a minute to talk about situations like minor beneficiaries and using a trust for that.
Yeah. So if you have minor children, you really want to make sure that you have a will in place and that there's a trust set up for them under the will. Otherwise, you're going to have the PGT get involved and be the trustee of that trust, which is a really challenging process and it kind of gets taken out of your hands. So I think the real benefit of a corporate trust company when you're dealing with minor beneficiaries is oftentimes appointing a guardian for a minor under your will is a really challenging conversation. And finding somebody that has sort of the emotional capacity that you're wanting to raise your child and the financial acumen is very challenging. So, when you're dealing with minor beneficiaries, you'll want to make sure that you have a will and you'll want to make sure that you've got trust structures set up in place under your will. So, essentially, those funds are going to be held for your minor beneficiaries either until they reach the age of 19, or you might want to have those funds held in there until they're a little bit older because, you know, a lot of 19-year-olds receiving a lot of money at that age are still not going to be managing those finances in the best way. Now, if you've got trust structures set up under your will and you don't have if you don't have those trust structures set up, then the public guardian and trustee gets involved and they will act, they'll hold those funds in their sort of investment accounts and they'll be the ones managing those finances. And a lot of that then becomes out of the guardian's control. Now, typically what I'll often see is the guardian who's been appointed under the will is not necessarily the most financially savvy individual. So sometimes clients will want to have a corporate trustee appointed to manage the finances to make sure that the capital of that trust is preserved because you're usually looking at quite long-term trusts here. So you want to make sure that there's enough in there to provide for the minor's sort of educational needs, housing needs long-term. It's also a lot to put on the guardian, right? So you've already, they have sort of another child or two in the mix, and then you also want them to manage this trust fund. So it can take a lot of weight off the guardian themselves and it can provide you with peace of mind. So I think there's a lot of value add when you're dealing with minor beneficiaries with respect to having a corporate trustee in place.
And in this trust, we can name, we can get pretty specific if you really want it, right? So I can say, I want to make sure that the top priority for withdrawal of these funds is to pay for my son's education, right? I want him to be able to go to the same school he's in. You could say that once he decides to get married, we're willing to gift X amount until, to cover the wedding costs or a down payment of a house. And you can even, stage in when they get access to the trust as well, right? So there is a lot of flexibility there that it's not as if once they turn 18, correct, that here you go, you're turning over whatever's in that trust. You can stagger it out.
Yeah, definitely. Like typically what we see is you'll receive like a quarter of the capital at 25, half the remainder at 30, and the full remainder at 35. And as you said, Joanne, like you can have sort of a letter of wishes, and we actually encourage this if we're appointed, that can set out very specifically what your intentions were with respect to the trust, because of course you know your child much better than we do, and we want to make sure that we're administering the trust in the way that you envisioned, right? So I think that's a great point. There's so much variety. Everyone's circumstances are different, and it's very helpful for us to know what your intentions were with respect to setting up this trust.
I think that's amazing. I think we always hear stories, like there's always horror stories that we're hearing if things maybe people didn't really know how to set things up properly. And usually when there's a horror story involved, sometimes it can involve the public guardian trustee as well. So if we go back to sort of setting the stage for a relationship using sort of a corporate trustee with a letter of wishes and all of that sort of stuff, then it seems to me that that relationship and that understanding is sort of there and makes it easier as you go along, as opposed to just suddenly having somebody drop in and have to look after it as best as they think needs to be done because they didn't know the situation from the outset.
Mm-hmm. What a great gift to give to your children, to the guardian, the guardian that's going to be looking after them, right? Because, you know, they're obviously going to set out if you appointed them with the best intentions, but they might not know even the full picture either. So it's great to be able to say, you know, this is a list of the things that are important to us and that we want for our children. And it just makes their life a lot easier. And that's so similar to what we talk about, you know, with having all these financial documents set up, and why we talk to clients about them is saying, look, we want to talk you through your whole legacy planning, so that you're not, you know, forgetting one of the very important documents. And so we've talked a little bit about the wills so far. We've talked about power of attorneys, but one other areas with power of attorneys I was hoping we could pick your brain on, Samantha, was what does a corporate power of attorney do?
Yeah, so a corporate power of attorney is going to be similar to appointing somebody to act as power of attorney, except a little bit more thorough, I like to say. So essentially, if we were appointed to act, initially we would review the power of attorney, make sure that we have the authority to act. We would contact the person's sort of family, their caregivers, and their support system to let them know what our role is moving forward. So we're essentially stepping in to become a part of this person's support system. We're not acting in isolation by any means, and we try and develop relationships with that support team because they're going to be the ones that know that person's sort of value systems and sort of financial history the best. So we start by sort of securing all like valuable and personal items and documents, that type of thing, gathering all information about like income, debts, expenses. We'll like redirect, cancel services, sort of automate any bill payments that need to be made. We'll, you know, cancel credit cards or debit cards if they're no longer useful. And we'll work with like, you know, investment advisors like yourself to sort of set out some investment objectives, make sure that everything is sort of aligned with the client's wishes at that point in time. And then we'll, of course, attend to any like negligent tax filings, make sure that we're filing any tax returns that need to be made, and then file sort of any tax returns that might be owing in other jurisdictions. So it's really like a full picture. We'd also look at any sort of documents, legal documents that the person is bound by, review the terms of the agreement just to make sure that we're all covered off there. So it's really just taking a bit of a weight off that family and that support system
Right.
who's already going to be going through a lot at that time if that person has lost capacity. So it's just sort of taking that piece of the puzzle off the table for them, but keeping them very much in the loop as things progress so that they feel like they have a good sense of what's going on.
Amazing. And I think we talked about this a lot when it comes to the will and what if somebody starts out on that journey. But what does it look like for a power of attorney? So if Melissa was saying, you know, Joanne, you know, we've been working together for a long time, I want you to be my power of attorney. But then I started the process and was like, oh my goodness, this is a lot of work. What have you done? And I said, I need professional help here. Is
Yeah.
the answer the same as with the executor, appointing a trustee as an executor, or how does that look? A trust service,
Yeah.
sorry?
So oftentimes in a power of attorney document, this person will have been encouraged to appoint an alternate attorney. So that would be the first step to see if there's an alternate attorney. But if you're wanting to appoint again someone to act as your agent, certain trust companies you can act as agent for the power of attorney. And so oftentimes under these documents, you will have been given the authority to sort of appoint a substitute decision maker. So at the end of the day, you definitely have the ability to do that and get some assistance, which is a positive thing because really acting as an attorney, you don't know how long that role is going to last either, right? It could be a very, very long-term role. So you could have been in the role for a few years and you've been managing okay or, you know, surviving. But at the end of the day, you couldn't see yourself doing this for another 5 years. So I think it's great to have that option available as well.
I guess what I'm hearing sort of the common theme throughout all of this is the relationship and working with the families, but sort of giving the families sort of the first sort of right of refusal or giving them the sort of the option, the first choice. And you mentioned something which I think is super, and I'm going to probably reference this a lot of saying, you know, that in appointing a family member or something as your executor or power of attorney, you're giving them a part-time job that they don't know how to do. I'm totally going to use that, like say that a lot because that's pretty amazing.
It's true.
But When you are talking to clients and they're considering trust, like trust services, it's a little bit more intensive, I think, than just saying, hey, you're going to give them a part-time job that they don't know how to do. Like, how do you respond when, the potential clients that you're chatting with say stuff to you like, oh, my kids can handle it?
Right. Yeah. So essentially, what I do is I just provide them with what a typical smooth estate administration looks like, right? So we're looking at, and that's not very common either, right? Like most estate administrations, you're going to hit bumps along the way. I think it's just more of like a knowledge and education piece because I think sometimes people haven't acted as executors themselves, or they think that their kids can manage it. And I'm not saying that their kids aren't, intelligent and savvy, and I'm sure that they can, but I think we often overlook the fact that a simple estate administration is going to take 2 years. There are lots of just little details. It's not really about being intelligent or not being intelligent. It's just about knowing what has to be done. And so them having that extra time and resources to figure out what needs to be done at a time where they're grieving, it's just a lot to put on them. And sort of as Joanne mentioned earlier, like I really think it's just a gift to your children to not have them have to do that. So that's sort of what I do with them. I just talk them through like what a simple estate administration looks like, and depending on their assets, it might not be simple. So I can sort of lay out what issues they're going to face, and just like the stress, it's just an extra added stressor and an already emotional time for the children.
Yeah, and I think a lot of times this is kind of the perception I feel a lot of people have is that they say, okay, well, if we're going to work with a trust company, that means our kids' estate is going to be less because of all the fees that they're going to be charged. So they say, yeah, we're going to save on fees by having our kids do all this work, so they get to keep more of the estate. And so I think it would be good for us to talk about the misconception that it actually costs more to use a trust service because, to my knowledge, we could in BC here charge up to 5% for, let's say, executor work, and we've had so many clients that have used a trust service and it costs a lot less than that. And they're getting it done right the first time in a fraction of the time. So maybe you could address a little bit about that narrative that it's very expensive.
Yeah, I completely agree with you, Joanne. So in BC, the Trustee Act allows the executor to, as you said, like claim up to 5% of the estate's value as at the date that the person passed away as remuneration. So that's any executor, right? Like not necessarily just a corporate trustee, that's anybody. So, and typically a trust company, I mean, it depends a little bit on the size of your estate, but as you said, you're looking at much lower than that, probably in the 2 to 3% range for sort of our trust company. I'm sure it varies. But at the end of the day, you may end up paying that amount anyway. Oftentimes, you'll appoint an executor, even if it's one of 4 children, who's like, no, I'm not going to take any remuneration. Like, I just want to do this out of the goodness of my heart. And 3 years later, the goodness of their heart has kind of worn out, which totally makes sense because they
So
realize like
true.
how much work it is, right? So, and then that's the stage when they're going to be able to get approval from the beneficiaries to be paid that amount of remuneration. So, you might end up paying it anyways. And at the end of the day, for me, I think it's going to be done a lot quicker having a corporate trustee involved.
Yes.
So it's going to be much less stressful because an executor who hasn't been an executor before is going to need that education piece. They're likely going to be paying advisors who are charging on an hourly basis more to learn that piece of information, if that makes any sense. So I think you're going to bear the cost of that either way if you've got an executor that doesn't have the knowledge base around what they're doing. And I think for me, it does, as we've sort of touched on earlier, having a corporate trustee in there, it reduces the potential for like estate litigation or conflict amongst the family members. And estate litigation is very, very expensive. You see it more than you'd like in my field. And so there's that sort of risk in terms of that, you know, financial risk as well that's being minimized by using a corporate trustee.
Well, and not to like just because tax is our favorite question or our favorite thing to talk about, but like not also, in terms, a lot of people don't realize what an executor fee will do for their own personal taxes too. So that becomes a whole issue as well for some people.
Yeah, I would love planning around that.
Yeah.
How much RSP room do you have?
Yeah.
Maybe we've done this before. I don't know. So when you're talking with families, what are some key prompts that jump out at you when you're having conversations that says, look, you need to work with a trust company?
Okay, so first off, I would say blended families are a big sort of growing demographic in our society. So when I say blended families, I mean we're on our second or third marriage, but you've got children from a previous marriage. So that's going to be a really unique scenario. Oftentimes, you're going to have a spousal trust under the will, for example, and this is a trust structure where you are paying out all the income to the second spouse, for example, but trying to preserve the capital of the estate for the children as beneficiaries. I talk to lots of clients who want to have the trustee of the spousal trust be one of those children. That is a very, very challenging dynamic for the second spouse to be coming to, their stepchild essentially, asking for funds and discussing their situation. So that can be a
Yes.
situation where a corporate trustee is very, very helpful, and it's a much more common situation these days. So that's, I would say, flag number one. I would say residency status of the executor is a big thing. So a lot of people wanting to appoint their
Okay.
children have U.S. resident children. And what happens is if the executor resides in the US, the estate's residency is determined by where the central control and management of the estate takes place. So this Canadian estate can be deemed to be a US resident estate, and this is going to make your estate very vulnerable to certain issues like, double taxation, for example. So it can be very, very costly. And just from a practical point of view, it's very challenging for a US resident executor to get everything done with respect to a Canadian estate. And then I would say, like, the third flag really is a little bit what we've touched on earlier. Like, if you have any beneficiaries of your estate that have a disability, have any mental health issues, any substance use issues, or any minor beneficiaries, a corporate trustee can just be a huge value add there. There's certain sort of structures available when you're dealing with individuals that maybe struggle to manage their finances, and you just want to have a trustee in there that's aware of sort of the legislative restrictions around those types of trust structures to make sure that they still qualify as those particular trust structures and you're still getting the benefits of all those trusts. So I would say those are sort of the three key for me. So blended families, residency status of the executor that you'd like to appoint, and sort of like any beneficiaries where you've got sort of, long-term needs to be thinking about. I mean, particularly with the last issue that I spoke to, these trusts are going to be ongoing for a very long time, decades sometimes. So in terms of having somebody else in those roles that isn't a professional, it's just a huge, huge ask at that point.
Exactly.
So if we think about, well, we're planners, Joanne and I. So if you think about working with sort of financial advisors, because we're going to ask this question because we're planners, but if you think about it from how do you work with financial advisors to ensure that an estate plan is carried out as intended?
Yeah. So actually working with financial advisors is really, really helpful for us. Especially we're sort of an independent trust company, which means we're typically going to be working with financial advisors who know the clients really, really well and are familiar with their family and their family dynamics, which is such a huge value add, in my opinion, of sort of working with an independent trust company. So we'll work with the advisor to sort of review the terms of the will and look at their estate plan and just discuss with them, like, long term, what did they know about the family in terms of their priorities and their wishes? Like, as you said, Melissa, I'm sure you've gone through like a financial plan for a lot of these clients. So you have a good sense of sort of what their priorities were and what their wishes were, which is really, really helpful. So I think at the end of the day, it's a real, real huge value add for us to have the financial advisors who have the long term relationship with the clients.
So, in closing, we thought it'd be great to ask you what's the one thing you wish everyone would understand about estate and trust planning?
Just one.
Just one.
Just one.
It's probably like 25.
I would say, honestly, the big thing and a big pattern that I see is not necessarily wanting to have these conversations. So, how I like to think about it is that this conversation around your estate plan is going to happen, and you can be there for a conversation or you cannot. In terms of just like having that conversation, being able to sort of explain your thoughts with respect to your estate planning, just so that conversation doesn't happen when you're not there, because I've just seen so many family relationships break down because there's a lack of understanding as to why the estate plan was set up the way it was. And there's just a lot of speculation. So I think my big takeaway would be, if try and have these conversations up front, because it just leaves a lot of sort of uncertainty sometimes after you pass away, and they are difficult conversations, but the difficult conversation is going to be had, either sort of with you or without you. So I think just thinking about it from that perspective.
I think everybody's heard of that family who might have a parent who told each each child something totally different about what they wanted. So you could imagine at the end when they're having a difficult conversation without them, that it's much, much harder from that perspective. So having it up front with the trust service person is fantastic.
So one of the great things with financial advisors working with a trust company is that there is continuity for the clients and what they've set up for their investment strategies. A lot of the time, like we get the pleasure of working with Solus Trust and Samantha and having those dialogues about, okay, here's why we structured the accounts the way they are, and we continue to operate the accounts as intended. So we can really honor a lot of our clients' legacy from that standpoint as well. So it's not as if, there's some firms out there that when you do work with the trust company, all the assets get transferred in and there's complete changes. With us at Raymond James, we don't have to do that, which is really great for the clients and keeping us a status quo.
It does seem to always breathe sort of a sigh of relief into the room whenever we start having these conversations.
Yeah, that's a lot of changes to ask people to do, right? You already have a family member losing capacity or passing away, and now you need to make an entire institution change and, get rid of, maybe not get to the opportunity to work with someone that you've been working with for years. Like a lot of our clients we've been working for 10 plus years. And to say, we can't be there to support you throughout all of this anymore is a big ask. Thanks so much, Samantha. It was so great having you here. I've learned so much today.
This is
Thank
wonderful.
you so much for having me.
Thank you for taking your time.
We're going to plug everything about Samantha on our website. You'll be able to find her under our team.
Thanks so much to Samantha Russell for coming on our podcast with us today to chat about the option of using trust services for your estate planning. It was really informative and we super enjoyed having her on.
Yeah, it was a lot of fun. As always, you can check us out on iowealth.ca, follow us on Spotify, or subscribe on YouTube.
Thanks so much for listening/watching.
Bye for now.
Corporate disclaimer. This podcast has been prepared by and with expressed opinions of Joanne Cabin and Melissa McGuire, and are not necessarily the opinions of Raymond James Ltd, RJL. Statistics, data, and other information presented are from sources RGL believes to be reliable, but their accuracy cannot be guaranteed. This podcast is for informational purposes only and should not be construed as an offer or solicitation for the sale or purchase of securities. Investors considering any investment should consult their investment advisor to ensure that it is suitable for the investor's circumstances and risk tolerance before making an investment decision. Past performance is no guarantee of future results. Information provided in this podcast is general in nature and should not be construed as providing legal, accounting, and/or tax advice. Should viewers have any specific questions and/or issues in these areas, please consult a legal, tax, and/or accounting advisor. RJL is a member of the Canadian Investor Protection Fund. Raymond James USA Ltd. advisors may only conduct business with residents of the states and/or jurisdictions in which they are properly registered. Raymond James USA Limited is a member of FINRA and SIPC. We hope you enjoyed the podcast, and for more information, please visit iowealth.ca.